Yeah, they can't take the fifth will off the property until the 36th month. Did you read the rental agreement?
Oh, sir, how do you have any authority to enter this in agreement and also turn the water off and tell them they can't come back to the property? Your right hand? If we could just speak one at a time, why don't you start from the beginning, with why we're here today for the claim?
We're here today for the contract breach of the trailer. We went into a rent to own contract, $750 a month for the space rent and $250 a month for the actual trailer. It was a rent to own. That $250 a month would have lasted about 36 months for the total to be paid off. We're basically here to get that back because of the contract termination, and as well as all of the fixes and parts that had to be put into it.
As well. So the contract you stated was, you said $750 a month for the space and $250 a month for the actual unit, and that was the rent to own portion, correct?
Yeah.
Okay,
The only thing I'm asking for back is not the $750 a month. That was for the space
correct.
rent. That's got nothing to do with it.
Okay. Except for the 2 weeks in July, it looks like that you guys had
Two
paid
weeks
rent
in
but weren't allowed
July,
on the property.
correct.
Okay. Um, so, and I did review, so there was a lot of like text messages back and forth and a lot of photographs. So can you just, I guess, was the contract for this rent to own, um, was that a written contract?
It was a written contract. You can see it in the pictures there that I submitted, but you just can't read it very good. I didn't have a
Okay.
good print to
That's
print
what I
off.
was kind of wondering. I think I thought that's what I saw, but it's very difficult to read in the exhibits. But
It
it's
specifically states a thousand a month for 36 months. That is $750 a month for space rent. That's
At this point, the agreement is clearly explained as a fixed monthly arrangement spread over 3 years with a total amount broken down into space rent, trailer rent, and an upfront deposit that had already been paid through monthly installments, which were recorded though not formally submitted as evidence. The discussion then shifts as the official asks for a clearer background to understand the claim, which includes multiple repair items, such as batteries, vent fan, roof vent cover, water heater, ceiling work, and waste tank components, including valves and pull cables, and there is some uncertainty about whether certain parts can be grouped together for simplicity. The focus then turns to examining each claim cost one by one, starting with the battery, where the response highlights that the original battery in the trailer was not functioning properly and needed replacement, and it is clarified that the work was done personally due to professional experience as an RV technician, which supports the ability to handle such repairs independently. It is also acknowledged that the property owner was not directly informed about the battery issue at the time because the situation was treated as a rent-to-own arrangement and therefore handled as if it were already personal property without seeking reimbursement or approval. The same line of reasoning is then applied to the other repairs such as the vent fan, roof vent cover, and water heater, where it is explained that these improvements were carried out with the expectation of long-term use, and while the owner was not formally notified, he was made aware in a casual manner during interactions.
I'm guessing that's pure for the unit itself with the $250 a month type of thing. Okay, good. And then we had the $105 for the 2 weeks in July. So why don't we talk about this 2 weeks in July for the $105?
So we were paid up throughout the end of July because of everything that was going on, the hostility, the harassment. We decided that it was best that we move on. We were paid out to the end of July. We were trying to find a place to take the trailer, and I had to come down here to Coos Bay for an interview one weekend. So we drove down here that weekend. We had taken a couple truckloads out to storage to make things a little bit easier. When it was finally time to move. And on our way down here for my interview that weekend, we got a text message from him with some language and calling me a druggie and a crankster to be exact, and that I'm not allowed back on the property, and that he's killed the water and power and everything else to the trailer. I advised him that I still have my things there. We still live there and we're paid out to the end of July. And he told me I'm not allowed back on the property. I can come get my stuff as long as he's with me. But everything else is locked out.
So and I think, again, I think I did remember reading this, but was there any eviction proceedings?
Negative. He going back when everything first started, um, he was trying to fight me at his house there, or at his mother-in-law's house, and ended up punching a thing right next to me, and then yelled at me that I've got 24 hours to get the trailer and the vehicles out, or he was going to tow them. So I don't know if that's considered an eviction, but there was no official eviction letters done besides just verbal. I'm going to tow your stuff. You need to get out now. Don't come back, kind of thing.
Okay, and is that when you left for the job interview, or did,
It was a little bit later, probably a week later. So
but he didn't follow through with towing in the 24 hours that he had,
nothing,
like, basically threatened to evict you guys?
nothing was towed.
But you had it was like a 36-month kind of your.
The situation then moves into a tense moment where it is explained that no formal eviction process was ever carried out, and instead everything was handled through verbal warnings, where the owner stated that the trailer would be removed and access would be denied, which created immediate pressure to leave. It is clarified that this did not happen at the exact same time as the job interview, but rather about a week later, and despite the strong warning, no actual towing took place within the short time frame that had been mentioned. The discussion then revisits the agreement to confirm that while the space itself was separate, the main contract focused on the trailer with a fixed monthly payment over a set period which shaped the expectations of continued use. Attention then turns to a critical event where access to essential services was suddenly cut off, as it is described that water was locked with a padlock and electrical power was completely shut down, leaving the trailer without basic utilities and making it difficult to live there. This action came as a surprise and was confirmed through text messages where the owner clearly stated that there would be no water and no electricity, and that access to property was being restricted, while also accusing the occupants and claiming they had already abandoned the trailer. In response, it is firmly stated that rent had been paid to the end of the month, and that personal belongings were still inside, which meant the occupants still had the right to be there, and the sudden shutdown of utilities was called out as unlawful behavior, while also emphasizing that no detailed updates about moving items were required since the agreement was still active and valid at that time.
Called the DMV to see if, what needed to be done, and they say it's never even been registered in the state of Washington. It still had on plates from somewhere else. He said, any problems, you can meet me here anytime and see where and how you want to proceed. 36 months, just what you signed. So 36 months is that $250 a month for the trailer.
So the big portion of your claim right now is the sale and deposit for this fifth wheel, right? So let's break down how we got to that amount, $7,550.
I think he said on one of them 14 months, the other one he said 15 months. So I can't remember if I did that to 15 months or 14 months, but 250 times 15 is $3,750, and then $1,000 deposit plus all the parts.
$250 plus times the 15 months that you had made payments on it, and then plus the $1,000 security deposit. And so the security deposit, did that in your agreement, the security deposit, it's really hard to tell again in the pictures. I guess, what was the agreement of the parties with that security deposit? Was there any language about him retaining a security deposit if certain conditions are met, or what?
I can't remember the exact wording. It had some wording in there, such as if they deem something.
Okay.
So basically, if it's clean and undamaged and so on and so forth. I think it was more for the property than the trailer, since it was a rent to own.
Right, it's a rent to own, so it's a little bit different in that regard. But okay, so the security deposit was just basically, it's like it probably encompassed the 36 months of the period that you would be renting to own, and also the space too. Okay. And you're just seeking to claim all of it looks like the repairs that you made yourself. And so you paid $400 for batteries.
Yes, and that's just the parts alone. That's not labor or anything. I'm not
Sure.
worried about the labor.
So it kind of comes down to three things we have right here. We have the sale and deposit, which would be kind of the big chunk of the claim, and then we have kind of the repair, you're seeking the reimbursement for the repairs or the parts that you used to repair the motorhome that was eventually taken from that, and then the $105 for the 2 weeks in July. Does that sound about accurate? We can have like three categories of charges right here. Okay.
Yes.
Okay, and then, all right, so I'm gonna ask you guys to mute, please. Can you please raise your right hand for me? Let's start from your perspective from the beginning.
Well, basically, it's pretty simple. It's $1,000 a month for 36 months. They moved out on month 14, 15. I can't remember which one it was, but we have receipts for all that. So they paid everything like they were supposed to. They moved out. They never received an eviction notice. They never received anything. This trailer was something that I brought up there that I got from my buddy, and we set it up for $1,000 a month for 36 months. The title will be signed over to him when he pays the 36 month. He can pull it off the property. He can do whatever it is he wants to do. Good to go. They only made it 14 or 15 months. I never gave them nothing. I don't know. They just moved out. I locked the water. First of all, the power was never.
The hearing then shifts as the other side is asked to speak and provide their version of events under oath, and they begin by presenting the agreement as a straightforward arrangement involving a fixed monthly payment over a set period with the understanding that ownership of the trailer would transfer only after full completion of payments. It is stated that payments were made as expected for a certain period before the occupants chose to leave on their own without receiving any formal eviction notice or written demand to vacate, which is used to support the claim that no forced removal took place. The trailer is described as a unit that was set up on the property through a personal arrangement, and the terms allowed the occupant to take full control of it only after completing the full payment period, which had not yet happened at the time they left. The explanation continues by addressing the utility issue, where it is claimed that electrical service was never disconnected, and that the only action taken was placing a lock on the water supply, due to concerns raised by neighbors about possible damage, which is presented as a precaution to protect the property rather than an attempt to force anyone out. It is also emphasized that there was no request made to remove the lock or restore access, which influenced the decision to leave it in place. When discussing repairs, it is acknowledged that some contribution was made toward a water heater early on as a gesture of cooperation with a new occupant, but beyond that there was no awareness of additional repairs or expenses, and no documentation was provided at the time. The position is reinforced by stating that ongoing maintenance or upgrades were not the responsibility of the owner under this arrangement, and that no approval had been given for such work, which is used to challenge the claims for reimbursement, and to clarify that the trailer remained under the original agreement until full payment was completed.
As far as the roof caulking, I mean, I just chuckle on that because I ordered a whole case of roof caulking off of my Amazon Prime account and gave it to him. So why am I being charged for something that I ordered on my account and just handed it to him? So I don't really know.
So the contract for this is $1,000 a month, but it's broken down, correct? $750 for the space and $250 for a rent to own for the trailer. Or the
Yes.
fifth wheel, right? Okay, so that contract was entered not with you, but the property owner?
Yes, ma'am.
Then how do you have any authority to evict them?
Yeah, that's what I'm wondering. And I didn't evict them.
Oh, but you locked the water, you parked cars and threatened to park cars in front of, so they couldn't take it. At
Right.
least that's
They
what your
can't.
text messages said. So you said there's nothing stopping them from taking the fifth wheel off the property, but you did.
Yeah, they can't take the fifth wheel off the property until the 36th month. Did you read the rental agreement?
Oh, sir. All right. If you can't keep things civil, we're gonna have a tough time here. So,
Okay.
reminder for you to keep things civil. This is a court of law. I'm a judge, so please remember that there's certain courtroom decorum that you must follow.
Okay.
Did you supply the rental agreement in your exhibits?
Yes, I believe so.
The problem is, I don't even know who the landlord is.
Can I tell you?
Sure.
That would be my mother-in-law, Gail Gerlach.
This agreement that I have, it's not signed by anybody. And the problem is I have a lot of these like handwritten things, so I'm not sure.
But anyways, my mother-in-law made that rental agreement for them to sign.
Who owns the fifth wheel?
My buddy.
But you... Okay, well, and how does your mother-in-law have the authority to rent out the fifth wheel?
Because what had happened is
For rent to own.
my buddy gave me the fifth wheel, said, take it. I'm done with it. They couldn't find the title. I said, okay, I've got a tenant that wants to move in or a couple that wants to move into this. did it 36 months, $1,000 a month, however you want to break it down. And so that would give a time to file for the lost title or whatever needed to be done. 36 months, we should have been able to get a title. It's paid for. So
Isn't it your trailer or your fifth
no,
wheel?
well, he gave it to me, but it's not legally mine yet because we don't have the paperwork.
So how do you have any authority to enter this in agreement and also turn the water off and tell them they can't come back to the property and park in front of the fifth wheel? That I'm just struggling to understand your involvement in all of this. If you're not the owner of the property, the owner of the fifth wheel, and I don't see any authorization for you to do that.
Okay.
I'm asking you.
I don't know.
Okay.
The exchange and focuses on how the trailer arrangement began, as it is explained that the unit was originally handed over by a friend without formal paperwork, and the intention was to use the payment period as time to sort out ownership documents, and eventually transfer the title once the full amount was paid. This explanation raises concerns as questions are directed at the authority behind the agreement, since there is no clear legal ownership established, and yet actions were taken such as entering into a rental contract, controlling access to utilities, and restricting entry to property. The response attempts to justify involvement by describing the situation as an informal setup, but uncertainty becomes evident when details about authority and responsibility are challenged. The discussion then shifts to claim breakdown of the arrangement, where it is stated that the occupants began removing their belongings in large amounts, which was interpreted as them leaving voluntarily, and this is used to argue that no formal eviction was necessary. However, this claim is met with contradiction, as it is pointed out that the occupants maintained they had not fully moved out and still had possessions inside, which creates a dispute over whether the departure was voluntary or forced. The explanation continues by bringing up concerns about possible damage to the trailer, which led precautionary actions such as restricting water access and monitoring the property. But inconsistencies appear when the source of these concerns shifts between statements from neighbors and direct claims involving the occupants. This leads to further questioning as the account begins to conflict on key details, and the difficulty in recalling events clearly adds to the uncertainty surrounding what actually occurred during that period.
That they made it.
So, but they paid through July, but you locked them out of, and you didn't allow them to take the fifth wheel off the trailer through the month of July.
Didn't allow them to what?
Take the fifth wheel off the property?
Yeah, it was never allowed to go off the property until
But you didn't allow
36
them to come to it either because you were worried that they were going to flood the trailer based off what your neighbor said.
Yes, but that doesn't mean that they couldn't. They came to it. That's why they were taking
But
truckloads up.
you locked the water. How are they supposed to return to that if you've locked the water? And they
No.
said that you turned off the power as well.
No,
How
I
are they
did not.
supposed, regardless, how are they
Yeah.
supposed to come back with no water? That's not a habitable living environment, and you would be in a lot more trouble if that were the case.
Okay.
So for this month of July,
Huh?
this month of July, they paid the full month of July. And you basically shut off the water, locked them out of you parked the truck in front of the fifth wheel so they couldn't take it off in the middle of July. So they could not benefit from the enjoyment of the property they had paid for.
Right. Yep.
So you're not disputing this $150 for the rent of July.
No.
It's your understanding that they just moved out. There was no, they didn't have any issues or anything they brought to your attention?
No, the issues were starting to rise. And when I put my foot down that it's not going to happen like that on my mother-in-law's property, then they
What's
started.
not going to happen like what?
What's not going to happen? Him cruising down the driveway at 30 miles an hour and almost hitting little kids. Drugs being on the property. That's not going to happen.
Okay.
So that's the way it. I'm sorry, but that's not.
I have no evidence to support that except for your testimony, so that's fine. But that is not in the lease agreement, that in the rental agreement that you have. There's nothing indicating.
Well, the rental
that's a
agreement
basis for termination. But
sorry.
You're the one acting in authority for your mother-in-law. You are the one that is clearly discussing and communicating with these tenants, and I'm guessing with the other tenants that are in the fifth wheels on that property as well.
Absolutely.
Okay, so you are acting on authority of your mother-in-law.
Yep.
Okay, so you do have authority to evict people or turn water off or do any other things that were requested by a tenant?
with the proper documentation.
What do you mean proper documentation?
Well, if you do an eviction, you serve them papers.
Correct. And if you cut off water, isn't that a constructive eviction?
No,
How so?
because I'm not going to have a trailer ruined.
But you don't know this.
Okay.
You're talking
well,
about something that I'm just asking. You shut off the water.
Yeah, I did. Nobody's arguing that.
Shutting off water makes a living situation uninhabitable.
Okay.
No,
Then-
that's accurate.
Do what you want to do.
Okay, well, if you have nothing further to say, then I will turn the attention back to Mr. Sims and Ms. Weicker. Can you please mute yourself, Mr. Murray?
All right. I'm unmuted
Mr.
here.
Murray, this is a courtroom. Please do not smoke while you're in court.
Oh.
You're really close to being held in contempt at this point, Mr. Murray. Please have more respect for the court of law.
The discussion then becomes more direct as a lack of supporting evidence is addressed, and it is clearly stated that the claims being made do not match anything written in the rental agreement, which raises concerns about how the situation was handled. Attention is drawn to the role being played as it is confirmed that the individual was acting on behalf of a family member and was the main point of contact for tenants, which establishes that authority was being exercised over property and the occupants. This leads to a key point where the process of eviction is explained, and it is emphasized that proper legal steps require formal notice and documentation rather than verbal demands or sudden actions. The issue of shutting off water is then challenged as it is explained that removing access to essential utilities makes a living space unfit for habitation, which can be treated as forcing someone out even without official eviction papers. The response attempts to justify the action as a protective measure, but it is pointed out that there is no confirmed proof that such extreme steps were necessary, which weakens that argument. The tone of the hearing then shifts as the court addresses behavior and reinforces the need for respect and order before moving the focus back to the other party to continue their explanation. The final moment sets up the next response as the individual is directed to specific evidence within the record that outlines their reason for leaving, which suggests that their decision was based on documented concerns rather than an unplanned or voluntary departure.
That was your understanding?
Correct.
Okay.
And it
so-
was so sporadic, trying to figure out what to do. But as far as the drugs go, Your Honor, I don't do drugs. I spent 15 years doing law enforcement work. I do not do drugs at all.
That's
So
not in
just,
question. I'm not considering
Okay.
that, just for
sorry, it hurts
I
my heart
understand.
to hear that. And then later on, here on page, what was that, 18, 19?
18 is what you're looking for right here.
Okay. So to answer your question, you asked him earlier, page 18, those
Mhm.
texts, we'll answer some of those questions. That was text messages between Dean and Christy. Christy said you put Gail in charge and you left everything up to her. Gail is his mother-in-law. He said he didn't leave Gail in charge of anything except to collect rent. That's why I'm on all bank accounts and I have full power of attorney and also have a quick claim to the house she lives in. So that tells me that he's the acting landlord and he's the acting property owner, basically, at that point.
And that was your understanding?
That was my understanding. I knew that was his mother-in-law's house, but my understanding was he was running the show there and he was doing everything there. I was also under the understanding that was his trailer that he was selling me.
So you thought he had made it, he told you that was his trailer to sell to you. Okay.
Yes, he bought it from an auction is what he specifically told me.
Okay. And then this rental agreement that you entered, it's hard for you to tell, but is this what it looked like to you guys with all of these like handwritten and highlights and color? Okay. I just wanted to verify. And is this your is somebody one of your handwritings?
That's yours.
That's my handwriting.
Okay. So this is your handwriting that you filled in towards this, is that you're just saying you acknowledge you received this. Okay.
Correct.
And then who did you sign this agreement with? Was it with Mr. Murray?
It
or
was
his
with,
mother?
was it with both?
They were both there.
They were
Both
both
there?
present
Okay.
at the time.
And he is holding himself out to be either the landlord or operating on behalf of the landlord. Is that?
Correct.
And then he presented it to you that he was the owner of the fifth wheel.
Correct. And he
Okay.
also was the actor as well that showed up for L&I for my L&I complaint on the property. He's the one that dealt with all of that as well. And you can see
Okay.
some messages there between landlord, between L&I and
Right,
myself.
right.
The testimony then turns to specific evidence as attention is directed to key pages in the record where text message exchanges are presented to clarify earlier questions and provide context to the situation. These messages show a conversation about who is actually in charge of the property and reveal that responsibility was not limited to simple rent collection as previously suggested. It is pointed out that there was a clear statement claiming control over financial accounts along with legal authority through power of attorney and involvement in property ownership, which strongly indicates an active management role. Based on this information, it is explained that the understanding was that this individual was effectively acting as a landlord and had full control over decisions related to property and the trailer. It is further clarified that from the beginning there was a belief that the trailer itself was owned by him and was being sold under that assumption, which shaped the agreement and expectations. This belief is reinforced by a statement that the trailer was said to have been purchased through an auction, which gave the impression of legitimate ownership and authority to sell. The discussion then reviews the rental agreement itself, where it is confirmed that the document included handwritten notes and markings, and that these were acknowledged by the party, who filled them in, which supports that the agreement was accepted and understood at the time. Finally, it is established that both individuals were present during the signing, and that the person in question was clearly presenting himself as either the landlord or someone fully authorized to act on behalf of the property owner, which further strengthens the claim that he held a position of control and responsibility in the arrangement.
I don't know what else to say. I mean, if I need to pay for July, then I'll pay for July. But I shouldn't have to pay for something that, number one, couldn't be taken off the property until the 36th month. Number two is, I don't know. I never authorized any of these repairs. So do you just buy a used vehicle and the guy has to repair it the whole time that you're making payments on it? I mean, that don't even make sense.
So what is your position when they brought up the fact that you said, like I said, I took 100,000 or 1,000 times 36. You are on month 15 with a full deposit paid. So on the first, why don't you hook onto trailer with a fifth wheel truck? And we are even. I will get you paperwork for trailer. You owe me nothing. I owe you nothing. That's what I was trying to call about.
Because I was gonna try to work with them until they started giving me a bunch of grief. And I called the attorney and he said, absolutely not. He said, Dean, they moved out on their own.
But then, but the problem is you have a writing in the text message that does modify the agreement, right? So he says, so August 1st, you keep security deposit and I take trailer and you sign title over to me. And you said, absolutely. I think that is fair. I was actually talking to Gail about that the other day. So you thought that was a fair resolution. So it seems like you guys had come to an agreement that they would move out August 1st. They had paid through the full month of July. And then you changed your mind because you thought they were going to damage the trailer that you said that you agreed that they could take on August 1st.
I changed my mind because of them threatening me when I was up there. So I don't know how you could do that.
Well, you were certainly acting with authority to do so, as you yourself had indicated in the text messages you sent, stating, let's see, did not leave Gail in charge of anything except collect rent. That's why I am on all bank accounts and I have full power of attorney and also have a quit claim to the house she lives in.
Okay.
So
that doesn't have anything to do with the rental agreement. I didn't write the rental agreement or the contract.
You are acting, but you have also testified under oath that you have authority to act on behalf of your mother-in-law as the property owner, and you hold yourself out to be managing the property, working with all these tenants the whole time.
Yeah, but I didn't put the terms in the rental agreement. That's not my handwriting.
Okay.
That's some cartoonist handwriting. I mean, look at it. Okay. It's an 80-year-old woman that drew it up.
Regardless, you are holding yourself out to be authorized to act upon it. You are texting the tenant saying you have authorization to do all of these things and then are threatening them to cut off water. So yes,
sorry.
You are holding yourself out to be that.
Can we please just make the ruling?
Sure.
Thank you.
All right. Firstly, I'm accepting all the exhibits in the file, so it's available upon appeal. In the small claims, Christopher Sims versus Christy Weicker, or Christopher Sims and Christy Weicker versus Dean Murray. We had an open court pursuant to a trial. Looking through the claim, to start off with the easy one that's not in dispute, I am awarding the plaintiff $105 for the partial payment in the month of July. That is no dispute whatsoever. You had fully paid, and then Mr. Murray had basically cut off ability to enjoy the property at that point. So that shall be granted. I am going to grant the plaintiffs the entirety of their claim. To break it down, the sale and deposit was $4,750. So that would be $250 a month times 15 months, which is $3,750 plus the $1,000 security deposit, totaling that amount. I find that Mr. Murray was acting with authority for his mother-in-law. He was holding himself out. In fact, in his statement from the defendant here, it says, "So I run a small RV park for my mother-in-law. I have decided to rent to Chris and Christy." So he is acting as the landlord, and I will be holding him as such, at least having the authorization to act as a landlord. So with the sale and deposit, it does appear through text messages, exhibits 10 and 18 provided by the plaintiffs, that they had come to an alternative resolution to where they had indicated that they had paid the full month of July. They were intending to move out August 1st, and they were wanting to come up with a potential plan to pay off the rest of the fifth wheel. And you agreed that they had paid in full and called it fair, and they could take it on the first of the month. You changed your mind because of other things that came up, and you're concerned about them flooding the trailer, but I'm not lending any credence to that at this point. I find that the cutting off of water and the threats that were made by Mr. Murray to the plaintiffs, and Mr. Murray, just for the record, is off camera while I'm giving my ruling, so we'll continue to do so. There he is. All right, so with that,